Good afternoon. Welcome to Cannabis Live. I'm Travis Copenhaver.
I'm Nicholas Galendez.
Today we're going to talk about the adult use application that was released, was it yesterday?
Mm-hmm.
Yep, just released yesterday. We're going to talk about some of the items to be looking for in there, general overview of some of the issues that Nick and I have been seeing since we've been reviewing the materials, and just a general talk about how to be prepared for an application process which starts November 1st. Before that, instead of news, we really only have one announcement. Just a few moments ago, the Marijuana Regulatory Agency put out another request to put together a work group. This work group specifically is going to be focusing on these special licenses. Those would be designated consumption licenses, temporary event operators and event licenses. And they're going to be holding a work group in the Traverse City area at the end of October. If that's something you're interested in, they're accepting applications through October 10th, and I'd encourage you to participate. I know that when attorneys from our firm have participated, it's always been a wonderful experience. Mm-hmm. So Nick, let's talk about this application that got released. What's going on?
Yeah, so obviously the results of voting yes on Prop 1. We now have emergency rules that were released a few months ago. I know that the MRA has been holding different sessions to licensees and people interested in entering the adult use market. As far as the application overview and instructions, both Travis and I attended a special one that was geared more towards attorneys who are helping different cannabis businesses in this industry to kind of get some more technical feedback and instruction from the regulators. But and what they had told us is that we are going to release this very soon in October so that everybody can see it prior to the November 1st submission window opening. So now, as Travis mentioned, yesterday they released an email that had links to every single application disclosure in paper form, the instruction booklet. It has the checklist for entities and individuals submitting the application, and a lot more detail on what that looks like and what the process is going to be for everyone. So I think our goal today is to kind of just to walk through that, and as Travis mentioned again, kind of just go over some differences that we've seen as we've looked through these documentations and thought about how the two differences in both application processes are going to affect everybody.
Yeah, and just so everyone's on the same page, the adult use licensing process is very similar to the medical version, where you need to have basically 3 steps between starting and final licensure. So the state application, just like on the medical side, really comes in 2 parts. There's what we are going to be referring to as the PreQualification application, and then the facility application. The differences are PreQualification is where you and the owners and stakeholders of your company go through a background check to qualify to hold one of these licenses. And then when you have that qualification and your facility has been built out and ready for inspection, you would be submitting the facility application. The third step is an important one. That would be municipality approval. So just like in medical marijuana, for adult use marijuana, your municipality is going to have a say in what types of licenses are allowed, where they're allowed to be located, how they're selected. Since this application came out, this is the state application, so we're going to be talking about the state application, not necessarily how it's going to be interacting with municipal applications. Just bear in mind that in most cases you're going to need to go through a municipal application process and obtain your municipality's approval, primarily so that you can have your facility be built out and constructed and ready for the second half of the state application. So Nick, let's start with pre-qualification. Mm-hmm. What is this kind of looking like? How does it differ from the medical version of pre-qualification?
Yeah, so I think it's, if you followed Michigan's medical application process from the beginning, there were certainly growing pains, and the licensing board, Laura was looking at it, the Bureau of Medical Marijuana Regulation. The Bureau of Marijuana Regulation would review the application, and the Marijuana Licensing Board would give decisions. After Governor Whitmer got installed into office, she eliminated the licensing board, and the Marijuana Regulatory Agency was put into place. What kind of happened from there was, a little bit of a relaxation in documents that were required. So what we saw was 3 years of bank statements, going down to 1 year of bank statements. Applications were being processed a lot quicker. Due to the differences in the medical law and the adult use law, what we're seeing now in the adult use application requirements is even a more relaxed disclosures requirements, and items and documents that you need are less stringent than what would be required for medical. And also, little bit of differences between if you're an existing licensee and if you're not in the medical framework yet. there's subtle differences there with what's required if you're doing a step one approval versus if you have to go through the full vetting process.
Right, and one of the things you can really tell here is the Medical Marijuana Facilities Licensing Act in the statute itself really dictated to the state, at the time the licensing board and then eventually the Marijuana Regulatory Agency, what the criteria factors were in quite a bit of detail. Which means in a lot of ways, because it's a statute, the Marijuana Regulatory Agency has to evaluate capitalization. They have to evaluate tax returns and bank statements, criminal history and civil litigation history, because the law requires it of them. So while they have eased up on a lot of those items, at the end of the day, they can't change the law as the department. It would require legislative adjustment to ease up any more on some of the application requirements in the medical system. Proposal 1, the Marijuana Regulation, Michigan Regulation Taxation Marijuana Act, MRMA, put a lot more kind of leeway onto the regulators to determine what factors are and are not relevant in this context. And, excuse me. And I think what we've really determined is these are some of the items that are of most import to the MRA in determining pre-qualification. And you can see they really just kind of streamlined this down to the bare bones. Mm-hmm. There's going to be several different attestations that applicants need to sign. And then we're really looking at, depending on if you're an entity or an individual, governing documents and establishing, just your corporate book for the MRA's review. And they don't even ask for tax returns. They're asking for 1 year of wage indicators, 1 year of W-2s, 1099s if applicable, K-1s, I guess. And really beyond that, everything else has been streamlined as well. Criminal history, for example, in the medical system, you need to disclose any time you've been arrested, charged, convicted, pled no contest, et cetera, et cetera, et cetera. Here in this context, you only need to list your criminal history if it's been a conviction. So no longer are we going back to trying to remember college days and, well, I remember getting in trouble. I don't think I was convicted of MIP because I did a program where
I just got a ticket. I don't think that was a thing.
Exactly.
We've heard a lot of that.
So it's really streamlined. I mean, if you have a criminal conviction, it needs to be disclosed. That does not necessarily mean you're going to be disqualified. But comparing the criminal history section, the tax return section, the civil litigation section, all of the disclosure sections, if you compare the adult use version to the medical version, almost in every situation, the adult use version is going to be simpler for applicants to work through.
Mm-hmm. And just kind of to piggyback off of what Travis was saying, the loosening of the requirements is tied to a section in the law, but it is kind of, the regulators are hamstrung by what's in the MMFLA, but the MRTMA doesn't have as much requirements. So the one it does have in there, though, is that the regulators can only ask for and vet you based on things that are relevant to running a cannabis business, as opposed to a lot of things that could be relevant to that, but also a lot of other things that I think a lot of people would agree with were potentially excessive and definitely hard to obtain if the records and certain documentation were so far outside the realm of things. Just like with criminal history, any arrest, any charge, any conviction, that could get pretty distant in the past. Whereas this one, the only disqualifier is that you don't have a criminal offense related to distributing a controlled substance to a minor. So, you may have a conviction potentially, and as long as it doesn't fit that criteria, you won't be barred from it. But you don't have to kind of go back and really try to pick your brain about what happened when you were younger or juvenile or any time in the past that you didn't keep records for things. But yeah, as Travis said, the attestations are going to be similar if you've been through the medical process. And then at that point, at least if you're applying as a company, you have to fill out the general information about your company, the associated parties, meaning any companies underneath it that have ownership interests or individuals that do, a little bit of information about your tax and tax compliance, no tax returns this time, government regulation, commercial licenses, and then litigation history. Along with that, other very basic corporate documents, W-2s, and litigation documentation, I think is another important one that they are going to ask for. But that's for if you're not in the system. If you're an existing MMFLA licensee and there's no changes to your organization structure and you don't have to make any material changes or proposed requests to change things with the MRA,
even easier.
Then all you have to really do, and this is the nice bright colored checklist, all you have to do down here is fill out very basic demographic information and then sign one attestation that gets notarized and submit it, except for, I think we can kind of unpack this a little bit, the social equity plan that is required for every single licensee, whether you're in the medical framework now and applying, or if you're coming on board for adult use for the first time. Everyone's going to have to submit what the regulators are calling a social equity plan.
Right, and the positioning of where you submit the social equity plan is a little interesting because it is part of the pre-qualification process as opposed to the facility process where you see some of the other narratives these companies are going to be putting together, you know, your facility plan, technology plan, staffing plan, etc. There's not a lot of structure to what goes into a social equity plan. In fact, the MRA is effectively asking applicants to present a social equity plan to them. We have a little bit of guidance from the way social equity works, you know, where the state is identifying municipalities that have, you know, hit criteria to indicate where equity is due. But what you really have is an opportunity to explain to the MRA what your company's individual specific plan is going to be to further the cause of social equity. And I think the companies that take that seriously and actually put a customized plan together that actually works for them are probably going to have an opportunity to really kind of dictate the direction social equity goes in Michigan. It's my personal belief that the state is doing this in this way because it's really difficult for a social equity plan to work. We've seen other states try to implement and tackle different social equity programs, and this is an opportunity for, instead of the state forcing some sort of social equity narrative requirement onto all these applicants, at least for this phase of Michigan licensing acquisition, it's really beholden to the applicant to determine what needs to go into that.
Mm-hmm. So let's just kind of, before we go on, let's say Travis and I are applying and we don't have a medical license. So what we'd have to do is create a company, let's say we're 50-50 owners. We would have to fill out the demographics, the attestations, create a social equity plan for the company, go through our history, you know, for the entity, which in most cases is newly created, and submit that. Since we're not in the system though, we would have to also submit supplemental applications for both ourselves and our spouses. If we both have one, you have one, I don't. So there would be 3 total supplemental applications. And then if anybody was a managerial employee, those people would have to go through the system and get pre-approved for a facility license, or I guess an establishment license.
And that's really improving as well. I don't mean to cut you off there, Nick. You know, in medical, you know, the Acela system where we're uploading all this information has continually been improved as the state, you know, kind of works out the process and evolves the application going forward. So just for anyone who's familiar with the Acela system, effectively a supplemental applicant will kind of have its own timeline of evaluation as opposed to the main applicant it's associated with. And if you happen to be a supplemental applicant associated with more than one business that's the main primary applicant, your pre-qualification will kind of stand alone a little bit to be deployed to the various licenses you might participate in.
Mm.
So it's kind of just an interesting nuance. It still kind of happens in the medical Acela system, and I think that's where they're moving towards. But by design from day one, it's going to effectively kind of have each supplemental applicant and applicant kind of have its own pre-qualification kind of timeline is my understanding so far.
All right, so let's say Travis and I are 50-50 owners of Nick and Travis's micro business. So we submit the entity application, and then we, you know, do we pay the application fee right away? Do we submit our supplemental applications? I think, you know, those are 2 important questions that now have kind of consequences if you do it in a different way. So let's say we submit the entity application and make the payment. Let's say Travis and I haven't really prepared our supplemental applications, and all of a sudden we get an email from the MRA saying you paid the payment. You have 5 days now to submit supplemental applications for everybody along with every other documentation that's required, or else we're going to deny your license. And this is something new that we've seen for adult use specifically, because there is a 90-day requirement for the MRA to issue a decision on things. So they've kind of split up the application, and they have timelines that they are holding against the applicants. And one of those things is it says they may deny an application, but you don't want to risk it. So what they've instructed all applicants to do is not pay, you know, you can submit the company application for the entity, but do not pay the application fee until all of the supplemental applicants have submitted their application as well, because then once you pay that application fee, you're on the clock. And after that happens, you still have 5 days throughout the whole notice of deficiency process to submit an answer. So one of the attorneys in our session had raised the question of, well, what if somebody on a Thursday submits something and then they're unavailable over the weekend? Is it 5 business days? And the MRA said no, the statute says 5 calendar days. So it's really important at this point, unless you have $6,000 to burn through multiple applications, to have all of your ducks in a row and really only submit and pay the fee if you have everything ready.
Well, let's be clear. The statute doesn't say calendar days. The MRA is saying they are interpreting it as calendar days. And I think it's important for us as the industry to note as well. Technically, the statute says the MRA has 90 days to process a complete application. What the MRA is doing is flipping that timeline back onto the applicant, which is probably reasonable, so that they can actually have a chance to give an answer in 90 days. However, if you have some sort of notice of deficiency, if something is listed as incomplete, and you're notified of that by the MRA, both in pre-qualification and in your facility application, you have 5 calendar days to correct that. So you want to be very careful. I know there's a few medical applications I've worked on where different applicants get comfortable. They know that they have breathing room. They might drag their feet on collecting that missing information for a week or 2 weeks as life gets in the way. If you are in the queue with your adult use application, it is time sensitive. If you're not ready or going to be in a position where you can respond in this 90-day window to any potential requests of the MRA, you might want to consider when to initiate the actual application for review. And the MRA has made it very clear you can start uploading information into the Acela system for your application. Once you submit the actual $6,000 filing fee is when your clock turns on. So bear that in mind.
so that would happen, and let's say our new application gets through and we get pre-approved. Kind of to step away from that real quick, if we were already a medical licensee and nothing changed, all we'd have to do, as we mentioned before, was sign an attestation, submit that with our social equity plan, and then we'd be pre-approved for an adult use license type. The next step for both scenarios, though, would be to submit the Step 2 facility license application, which, and this is another time-sensitive project, you'll be signing an attestation form and promising that you will have the facility pass an inspection by both MRA and the Bureau of Fire Services within 60 days of you submitting that Step 2 application. So in a lot of cases, in all cases, you need that local approval and you need the facility. Depending on if you've been in the medical system now, you may have submitted your Step 2 very early in the process before you started construction. You might have submitted it when you had the architectural and engineering drawings done, but not really started on construction, kind of all the way down. Everybody's excited to get started and get the first plants in the ground and get the first sales in their facility. But really, based on that 90-day timeline that the MRA is set on, they want to make sure that you are ready to open if your inspection passes. So again, if you're not ready, you need your certificate of occupancy or a temporary one. The facility needs to basically be ready to open the next day or even that day that the MRA and BFS come out. If not, and this was discussed amongst the attorneys as well, was that is BFS or is the MRA going to be lenient when there's scheduling issues, if they come in and they need some type of equipment that needs to be special order, that needs to be then transported 2 weeks, will be delivered in 2 weeks from now. They did say, again, that the rules and regulations say that the MRA may deny a license, but again, you don't want to test that. So just kind of to emphasize again the fact that, there's the 5-day window for responding to any notice of deficiency, item or document that they have clarification on. But then do not submit your Step 2 until you're absolutely ready to schedule an inspection and have that happen.
Right. So a natural question you might be asking for pre-qualification is, well, it's so much easier than the medical version. What's the point of being in the medical system? Well, just remember that one of the application requirements for most of these adult use licenses are that your company needs to hold at least one medical marijuana license in order to apply for the adult use license. So you've already gone through a medical prequalification if you're going for a adult use class B or C grow license, a processor, a marijuana retailer, a safety compliance facility, or secure transporter. If you are hoping to have one of those specific license types in the adult use system, the company that submits this application has to hold at least one medical marijuana license. So if you, in theory, hold a medical marijuana license, you've gone through prequalification as have all your stakeholders. The two licenses that are, well, I guess there's the special use licenses, or the special licenses too. There are two licenses specifically for Michigan residents. Those would be the micro business and the Class A 100 plant count grow license. So if you are either hoping to be a micro business or a Class A grow license, or any of these special licenses, that'd be temporary event organizer or designated consumption facility, you are the ones who are doing this new version of the pre-qualification. If you're a current medical marijuana license holder, you've already done pre-qualification, you mostly just file new attestations, is what it seems like. So, you know, that's basically kind of the new impact of pre-qualification. There's not too much new on the facility side of things. The facility application is very similar to the medical version of it as well. The only real nuance there, as Nick's already identified, is you're going to have a 60-day window. So if you're not 100% confident that your property is ready to pass BFS, if you're a grower or processor, or if you think that there might be some unforeseen delay or issue as you finalize your build out, that 60-day window may or may not be something you can work with. It might be in your best interest to, you know, on the side of caution, wait until you know that 60-day window is going to be something you can work with. So.
Yeah, and I think too, you know, a lot of existing facilities are going to be kind of remodeling their existing facilities to adhere to the rules for both adult use and medical, where, you know, the inventory has to be physically separated from one and another. Also to make sure you don't bundle products that are in the medical system with the adult use system, which is subject to different taxes. A lot of those changes and also changes to ownership are going to have to go through the medical process first. So what the MRA told us was that if there's any changes to your medical license, for example, if you're one of those applicants going through medical into the adult use system, any changes need to be resolved through the medical framework, through your analyst there, which will then, I think, kind of flow through towards your step 2 facility, or sorry, establishment plan and establishment license through the adult use system. One thing too that we've seen is that, as Travis mentioned, the facility plan or the narratives for the establishment for adult use are mostly the same, save the social equity plan. But also for certain, for retail establishments and for micro businesses, you will have to submit a responsible operations plan, which kind of details how you're going to prevent selling to people who are over intoxicated, from checking IDs and making sure that no minors under the age of 21 are buying product. Also, especially for these new special licenses that have to do with temporary events and making sure that age is restricted and everything is followed according to the law. That's another kind of nuance with for some of the operators that you're going to have to create and submit. There are more requirements with that compared to, say, the social equity plan. I always, my thought was that if for social equity, you can say at a minimum we are going to attempt to hire minorities. And that could be your social equity plan. Certainly, I think what the MRA has said is that we're going to be posting these online and wanting to be able to be transparent and have these operators be accountable for what they're saying they want to do. But the responsible operations plan will have to have that criteria specifically in the rules that I just mentioned about making sure that we're not overselling to people who shouldn't be consuming. Right. So on and so forth. So.
And since we are shifting to, there's not as much to discuss, obviously, for the facility portion of things. One interesting distinction, since we're talking about nuance, is employees. For medical marijuana businesses, you can hire employees that are 18 years of age or older. Medical marijuana is different from adult use marijuana in that an adult use marijuana establishment cannot hire someone who is not 21. So if you are an existing medical marijuana business with employees that are 18, 19, 20, and you want to add on or pursue any of these adult use licenses, just bear that in mind. That seems to be one of the more obvious distinctions between the two programs from the facility portion of things, in addition to social equity. Mm-hmm. The only other thing I'll mention, because I've seen this several times in the last few days, and I don't know where this kind of idea is coming from, But several people have asked me if you, for the residency required businesses, the Class A grow and the micro business, there seems to be this rumor going around that you need to be a Michigan resident for 3 years. I have no idea where that's coming from. That's not in the law at all. Understand the Michigan residency requirement has no historical timeline to it. If you currently don't live in Michigan and you want to be a micro business or you want to be a Class A grow, move to Michigan, establish a residency, and then when you are a resident, you can apply for those licenses. So, any other tidbits or nuance you've been identifying so far?
I think the only other thing I wanted to flag was that if you are a social equity applicant, I know the MRA has gone through a lot of that in separate sessions all around the state. And they did recently, in addition to talking about the work group, the MRA did announce that it expanded some of the cities that where residents are who are, can apply for the social equity program to be an applicant. You have to go through a certain application process for eligibility requirements beforehand. And if you do that, there's a section on the entity application disclosure form that has you put your information down and kind of a social equity ID number, which then will assist the department in giving you the discount on the application fees and all of the other benefits that are associated with that. So we are seeing a little carve out for that, and that process will then be easier for the MRA to identify that and give you that discount on your application. So I think that's kind of the only other nuance. And I know when they showed us the online application, there's also a button where you could choose if you were an applicant and enter in your number. So that kind of all links together.
Yeah, so basically what Nick's saying is if you qualify for, or if there's going to be people on your team that are going to be able to qualify for that social equity reduction of fees, you do that first, and then you have a number that you then plug into your application. Mm-hmm. So I think that's probably going to do it for us today. All of this information is available at michigan.gov/MRA, and there's different buckets, one for medical, one for adult use, one for the marijuana caregiver patient system. So all of this information can be found there. I will say, good work to the MRA. The instruction packet for the adult use application is so much more useful than the medical version was when that first came out. Granted, they've had a couple years to kind of make that all good and work. Mm-hmm. So go to michigan.gov/MRA, read through these materials yourself. If you're either an applicant or a hopeful applicant, you should know how this all works. This is basically one of the biggest steps to getting your license, and it would behoove you to familiarize yourself with it. Mm-hmm. So thank you for joining us this week. We'll be back next week with another marijuana topic to discuss on our Facebook show. And for Travis Copenhaver,
Nicholas Gwendez,
thanks so much. We'll see you next time.